This is Samuel McGee, and you're listening to the Ascent with Crestmont Private Wealth on Bernie Radio 103.9 FM.
The opinions expressed are those of the host. The material is for informational purposes only. It does not constitute investment advice, and it is not intended as an endorsement for any specific investment. Visit CrestmontPW.com for more details.
Welcome to The Ascent. This is Sam McGee with Crestmont Private Wealth, CEO and owner. We have offices in Houston, Texas, and Bernie, Texas. And we have a very special guest on the show today, advisory client Scott Seidl. He's a lawyer in Houston, Texas with Keene Miller, LLP, and he is of special counsel. Scott, welcome to the show.
Well, thank you for having me, Sam.
I know you've got a few things you need to put on the compliance docket here, so go ahead and do that, and then we'll get started right away.
Absolutely. As Sam mentioned, my name is Scott Seidl. I'm an attorney with Keene Miller here in Houston, Texas. And just for purposes of this podcast, anything that I state is for general information or made for entertainment purposes. And anything said here is not a substitute for legal advice and does not create an attorney-client relationship. Should you have any issues, I strongly encourage you to contact the lawyer of your choosing.
Thank you, Scott. Okay, with that out of the way, we are going to talk a little bit about the do's and don'ts as it relates to setting up your estate. Because, you know, we all hear the old adage of, hey, you know, you need a will. You need a will. Everybody knows that. You own anything and you care about where it goes and you care about your loved ones, you should have a will. So let's just move on past that. You've heard that on the show. If you're listening to this show now for the past 2 years, you already know that. But today, I want to talk a little bit more about the consequences or the potential consequences and the risks involving not having your estate properly accounted for, set up properly in the event that something happens to you in incapacity or premature death, and what that can look like for the business and the family on a go forward. And Scott, when we met over at our event in Houston about a little over a month ago, you know, you brought up a few things that really kind of opened my eyes about going down into the Harris County Courthouse, which is a process, by the way, and, you know, going down there and representing people in litigation, estates in litigation, trusts, and all the different disputes that you encounter. And obviously, I don't know anything confidential, nor can I. But could you share a little bit about some of the pitfalls that you see in your day-to-day?
A lot of good points made there, Sam. And specifically, I always tell my clients, you know, an ounce of prevention is better than a pound of cure. Now, my particular practice area, as you alluded to, is the cure, not the prevention. I do not myself do any planning. However, here in our office, we have a very, very strong planning practice. That being said, things can and will go wrong from time to time. So the more effective and the more comprehensive your estate planning is, whether it be wills, trust, declarations of guardians, so on and so forth, that make those types of documents and having that in place makes my job that much easier. But when things go wrong in this area, they go seriously wrong. Again, not being able to discuss specifics, but, you know, a will contest or an estate contest, you are looking at years in the courthouse and many tens of thousands, if not hundreds of thousands of dollars to resolve that. And typically, no one ever leaves those types of cases happy. Even if you win, you don't really win. Unfortunately, it's not entirely possible to prevent all disputes. That's just kind of the nature of things. However, I can't reiterate enough how important having that plan is in place.
When you talk about the disputes, I think that in the listener's eye, they probably see high-profile ones, right? So there's probably ones that someone right now is listening to and going, oh, yeah, I remember when so-and-so, you know, a famous person or a large business had a huge, a huge family and there was a contested will or something that drug out in the public eye. But, you're here dealing with this day to day with, I would say, more common folk. I won't call them commoners, but I do have a little humor on this show. But you do see tons of businesses and business owners and estates that have title to them. And so how often do you see this? I mean, obviously you're in the profession of it, so it probably keeps you busy, but is it really often that estates are challenged?
Fortunately, it's not, although there is no magic formula to, where I could articulate this type of estate will certainly be challenged versus another estate not being challenged. A huge part of it is personality and family dynamic. And what we're seeing now is due to divorce rates and remarriage and blended families and, just the sheer amount of wealth in this country. I mean, you don't have to be Warren Buffett or that level of wealth for a dispute to break out. But, we're seeing a lot of really a big driver behind our practices. Again, the blended family breakdown, kids from a first marriage disputing with a step parent or step siblings fighting over the remnants of, whatever the second marriage generated, things like that. There is certainly an undertone of, I was going to say greed, but I think misunderstanding is probably a bigger driver than just sheer greed. I mean, if kids don't like their step parent, that is a recipe for somebody having to call me and hire and either defend a contest or prosecute one. But it's interesting because wealth is not really the biggest indicator about whether a dispute will break out. I firmly believe, and I was thinking about this before I came on today, it is a lack of communication and having those hard conversations when someone is still with us about their wishes, and then having those wishes translated into legally valid and enforceable documents. I think a lot of our clients, maybe they do go through with the planning. However, if you do a plan and you keep it in secret, then your heirs, whomever they may be, there's a lot of surprise factor in that from time to time, and that generates a lot of work for us.
Yeah, that's a really, really good point. I went to the Schwab Impact Conference last year, and this is not a major digression. It kind of supports what you're talking about. And I listened to a really great author and public speaker, Simon Sinek, and he actually used an example of a study that had people in a room that would articulate a message to another party, but they had to do it by tapping their fingers to the tune of a song. And the study was really eye-opening. It was that something like 85% of respondents felt like they could tap the tune of a song on their finger and that the other person would get it. And that the receiver was also extremely confident that they would be able to name it. And then turns out, lo and behold, like 2.5% of people actually could do it, right? And so I think that gets back to your point of communication, that even when we do communicate, sometimes it's not received correctly, or maybe it's not received thoroughly. And so that really advocates for the point of having a living, breathing plan with communication with your family, all the related parties and generations that will be touching the asset or family asset or inheritance, so they can have a clear understanding of what's to happen. Now, do you believe that if communication were better for the, call it the wealthy family, the business owner, that is kind of step one in maybe putting you out of a job?
Well, I think step one would really be having the plan in place, whether that was communicated to the heirs, the family, whomever, because again, the plan, there are guardrails, if you will, put in place by the law that, if we don't have to share wills or trusts or things of that nature with potential future beneficiaries, especially, a will is a revocable testamentary instrument. So people are always free to change their mind. But so the plan being in place is really step one, but then communicating about what the plan is, even if that doesn't involve sharing, specific documents, things of that nature. I think that's really step two. But I say that, and I may be an outlier in my profession on that, in that I think the conversations are important, but I base that on, I firmly believe that what is mine, I am free to do with it what I want. And I've actually had that come up in several cases where specifically children were unhappy with bequests that, their parents made, and I've had to have I call it the sins of the father conversation with them, where it's like, well, that's fine, but, mom or dad was completely free to do with their things, whatever they chose. And I'm sorry you feel slighted by their decisions, but that's what the instrument is telling me is supposed to happen with, whatever asset we're discussing.
Yeah, it kind of is what it is. And when you think about contested estates, sometimes that could be more of a questioning of capacity, mental capacity, judgment, et cetera, et cetera. Do you see that very often? Is that something that enters the courtroom?
I am so glad you brought that up, because yes, that is a huge driver in, I would say, probably 75 to 80% of all the contested will cases that we handle. And the solution to that, in my mind, is do not wait to get your plan in order. I know sometimes that is unavoidable, but either, waiting too long and then there even being a question of capacity when a document is executed, that is a fertile breeding ground for litigation. And I'll tell the listeners right now, capacity fights are exceptionally nasty, exceptionally long, and expensive. And we have a procedure in the law called a summary judgment, which is a disposition of a case by a judge if there is no issue of material fact. That's a bit of an oversimplification, but for today's purposes, I think that works. Capacity fights are seldom summary judgment cases. And the purpose of summary judgment is to shorten the case and bring resolution quicker. If a capacity challenge is made, it is highly, highly unlikely that a case will be ripe for disposal via summary judgment, meaning you're going to go to trial and you're going to spend a ton of money fighting about it.
And that is not wealth creation or preservation. That is wealth destruction. So you heard it here. Scott Seidl, lawyer in Houston, Texas. He really specializes in some of these contested wills and estates. Get your plan in order. At Crestmont Private Wealth, we do full planning and wealth management, including investment management, but it all starts with a plan. And some of these things we talked about today, as Mr. Sidle has alluded to, are avoidable by having something like a power of attorney or a very concrete estate plan. And so reach out to us if you would like to speak further about it at crestmontpw.com. And Scott, how would someone reach you if they wanted to continue this conversation?
So I can be found at our firm's website, which is keenmiller.com. That's Keen with a K. Or you can find me on LinkedIn. I'm very active on there and, try to do my best to monitor messages and so forth. So, if you have any questions or would like to speak with me, find me there. I'm happy to direct you to any planners if you're in that stage of this process.
Excellent. Thank you, Scott, for being on the show. We appreciate your wisdom and your insights into really a very kind of dark subject, but one that is important to take care of. And so we thank you very much for being on the show.
Absolutely. I appreciate you having me, Sam.
Thank you for listening to the show. My name is Sam McGee, CEO and owner of Crestmont Private Wealth. If you'd like to reach us, you can find us at info@crestmontpw.com or on the web, crestmontpw.com. We would love to hear from you. If there's a subject matter you'd like to discuss, or you've got someone that could come in and inspire those here locally on the show, we'd love to meet them too. Have a great weekend, and God bless.